All right, we're starting. I hit the start button, so let's get started.
Yes, but Marty, there is feedback.
I'm not sure what the feedback is from.
Abby, you're getting it?
I am. I'm going to mute myself.
Jonathan, I think it's you. You should mute.
All right, let me mute myself.
Welcome to the program. My name is Marty Shenkman, and I'm joined by Chris Lauer from Madigan and Brodigan, if I got it right. If I didn't, he'll correct me in a second. Abigail O'Connor from O'Connor Law, and Jonathan Blattmachr. And this is a follow-up webinar on the Corporate Transparency Act. We may refer to it as the CTA for short. The Corporate Transparency Act becomes effective January 1, which is around the corner, and everybody needs to deal with it. The impact of this is going to be monumental. The confusion is dramatic. The uncertainties are dramatic, but none of that's going to prevent us from having to deal with it. So before we get going, we're going to have a quick word from our sponsors and some quick webinar pointers. The PowerPoint is available for download from the webinar console during the program. You're going to have multiple options to get not only the PowerPoint, but an article and maybe some additional materials and a recording. I will post it to my firm website within about a week. Peak Trust Company, one of the co-sponsors, will post it to their website shortly after this, as will Interactive Legal. And I think Interactive Legal will tell you about a whole landing page they have with all sorts of Corporate Transparency Act information. We do not give out CLE or CPE, but do issue a certificate of attendance. If you have questions, email the panelists. Don't post it in the Q&A on the website. And what we'll do is individually answer it. And all the email addresses, if you're missing any, are available in the last slide in the slide deck. Beth, you were going to make some comments on behalf of Interactive Legal.
Sure. My name is Beth Bemke, and I'm the Director of Content Development at Interactive Legal. And we are very proud to have the opportunity to sponsor this webinar on what we think is a critical topic. We are in the process of working with the challenges that the Corporate Transparency Act is presenting by drafting language that we anticipate will be included in LLC operating agreements, limited partnership agreements, trust agreements that will be giving specific authority to deal with those challenges. We're going to be revising engagement letters and creating new engagement letters specifically for CTA compliance work. We're working on sample letters and memos to send to clients who need to report by 2025 and on practitioner checklists to help you get your firm ready for CTA compliance. We will have all of these available for our subscribers. Some will be publicly available on our website at interactivelegal.com. We have a CTA resources tab for our Attorney Resource Center for the Corporate Transparency Act, which provides links to documents as we get them available, as well as resources and links directly to the FinCEN site so you could actually read the law for yourself.
Which won't answer most of your questions, just saying.
Well,
but we'll all be learning together as we go on. Andre, are you on for peak? I see Andre trying to get on. I'm not sure if he is.
I am here. Yeah, I'm having some technical difficulties with the camera. However, I am here.
I will vouch for how handsome you are, but why don't you just speak since we all can hear you?
So thank you, and welcome everyone for attending today's seminar. My name is Andre Sears. I am the Business Development Officer for Peak Trust Company, and we're pleased and honored to be able to sponsor today's presentation. Peak Trust Company offers a full spectrum of trust services, serving individuals, families, and their trusted advisors. We offer flexible and customized administrative services for all types of trusts. Peak Trust Company is built from the ground up to provide a better experience for clients and their advisors. I invite you to visit our newly designed website at www.peaktrust.com. If you should have any questions, feel free to reach out to me or any member of the Peak team. I appreciate you giving me the opportunity, Martin, and right back to you.
I think it was about a week ago, Jonathan, I, and Matt Blattmachr, who's the CFO, if I got the title right, of Peak,
CEO.
had an interesting.
Matt's the CEO.
All right, one letter off. CTA, CFO, CEO. We had an interesting discussion about some of what might happen when people do not cooperate and do not file that have to, and what Peak as a trust company might do to address that. And they've put a lot of thought into it, and I think those are the kind of thoughts we're all going to have to deal with. Before we kick it off, and I'm going to let Chris lead the charge, just a comment on what Beth said a few minutes ago. It shows the absolute breadth of how much of practice will be impacted by the CTA. Beth rattled off a whole array of legal documents across the T&E and corporate/LLC entity world, all of which may be modified. She mentioned modifications to engagement letters, retainer agreements, whatever we call them. Practice standards are going to be modified. This stuff will affect almost every area of practice. It's pretty significant, the impact. So let's get started. And what we're going to do, and I'm going to let Chris do this first. I always hate when I go to a program and maybe I don't know the basics, and what somebody could give me in 5 minutes to help me at least follow the program, they don't bother with, and then it's hard to struggle through the rest of the presentation. So Chris deserves credit. It was his idea. Even though we're going to kind of focus on a deeper dive, we're going to take 5 minutes and just define some terms and give you the basics. So if you've been not focused on the CTA, you'll get up to speed and be able to get more out of the program. Chris, just holler when you want me to advance the slide if I don't do it, and let's give a quick overview.
Can I just interrupt before Chris says something? Marty, do you want to say a word if somebody wants more on the background, where they can find more on this background, maybe perhaps with a prior webinar?
Well, Peak and ILS and my firm website all have multiple programs, recorded programs that we've done. There was an extensive article that you, Abby, and Jonathan and I worked on that is posted to both the web console and to all 3 websites. Chris prepared an additional background PowerPoint that we're not going to even go through today. So if you want some more background, that's posted to the web portal, as well as the PowerPoint that we are going to use. So there's a bunch of resources. FinCEN actually has a few good resources. The preamble and the regs, I think those are about 312 pages, light reading for preparing. They have a small business guide that's actually quite well done and has graphics that I found helpful. They have FAQs that you also need to go through, because they address some stuff in the FAQs that's not in the actual regulations or discussed in the preamble. If I missed anything, Abby, jump in. Okay, Chris, take it away.
All right, thanks, Marty. So it's important when we're going through this to recognize the Corporate Transparency Act is anti-money laundering legislation. It's designed to make it harder for bad people to use shell companies to obscure beneficial ownership interests. So FinCEN has decided to draft legislation. Congress's draft legislation, and FinCEN has promulgated very broad regulations to sort of capture any company that could possibly be treated as a shell company. A shell company is just a company that does not have significant physical operations. Reporting companies under the Corporate Transparency Act are going to need to identify and report personal identifying information on all of their beneficial owners and also on their company applicants through reports that on beneficial ownership information. So there are 3 important terms here, right? We've got reporting companies, which is any entity formed by filing paperwork with the state Secretary of State. Some states style that differently. I know Alaska has our Department of Commerce. and some different states will vary somewhat, but also tribal jurisdictions and foreign entities that are registered to do work in the United States. There are 23 exceptions. They're fairly narrow, and they will not apply to most clients most of the time. There are also some exclusions just definitionally. General partnerships and sole proprietorships are not going to be entities because you don't have to file paperwork to create them. Similarly, trusts and estates, they're not entities. They're not created by filing with the state. Now, there are probably some exceptions there for things like Massachusetts trusts and certain Delaware trusts that are designed to do business. But by and large, the trusts that we create are not going to need to comply with the Corporate Transparency Act as reporting companies. Beneficial owners, on the other hand, is a much broader category that trusts and estates might be part of. A beneficial owner is anyone who owns or controls, directly or indirectly, 25% or more of a reporting company's ownership interest, or someone who wields substantial control, directly or indirectly, through any type of understanding or relationship whatsoever over a reporting company. There are a handful of exceptions from who's treated as a beneficial owner, so minors, certain inheritors, agents, employees, and creditors who lack substantial control to direct a company. People who have authority over trusts can be beneficial owners if the trust owns or controls a reporting company. We often create LLCs to hold things like interests in property, interests in real property or small operating businesses. These are common things that we do, and that can very easily create a trust, and everyone who has authority over the trust to be treated as a beneficial owner. We're also going to need to worry a little bit about company applicants. That's the natural person who files entity formation paperwork and the person who directs that the filing happens. So typically it will be an attorney and their paralegal who they tell to file organizational paperwork. You can go on to the next slide.
Chris, this is Jonathan. Let me ask a question, if I might. As you know, my brother and our two best friends own a remote piece of property in Alaska on a wild and scenic river. And there are 5 of us who are owners, and each owns 20%. Now, we're an LLC, and the question is, we don't have any president, we don't have a chief executive officer, we don't have general counsel. You know, when we want to do something, we contact each other and decide whether or not we're going to do something. Now, do we avoid this because we don't have any 25% or greater owners, and we don't have anyone who wields, at least alone, substantial control?
Yeah, that's a really good question, Jonathan. FinCEN has told us in its final regulations, they expect every company will have at least one beneficial owner. I don't think that you would be able to avoid a requirement to report for the company simply because all of the responsibilities are diffused. I think they're going to treat everyone as being a beneficial owner in that circumstance.
Let me just highlight a comment, and this is something that advisors are struggling with, especially if you're still getting into the area, but clients are going to really struggle with. Chris has defined a beneficial owner and then went on to talk about people with substantial control that own nothing. Clients are not going to understand wait, I don't own anything. Why am I reporting? It's going to be some of the stuff we talk about. Chris?
Yeah, it's going to be a huge crisis, and in part, this points to one of the problems with the law is there's a division between who has information and who's responsible for reporting that information. Reporting companies are responsible for filing accurate beneficial ownership information reports, and so they need to keep track of all of their beneficial owners and report all of their beneficial owners' personal identifying information, and they can do that in the form of keeping the information themselves.
Yeah, Chris, this is Jonathan. Are you telling me that the individuals, the beneficial owners, don't have a reporting requirement? It's just the reporting company? Is that the way that this statute works?
This statute is designed to place the primary responsibility on reporting companies. For senior officers of a company, if it has any, they are the ones who are going to be on the hook for any failure to report. And I don't know what FinCEN is going to do for a circumstance where there are no officers. Certainly, they want to make sure that no one is abusing the LLC format to launder money, and they've told us that they think they're going to do this in a very expansive way. So the law says that if you are a senior officer of a company that fails to file an accurate report or files a false or fraudulent report, you're liable. Now, the person who causes false or fraudulent.
When you say you're liable, what is the effect of being liable?
Well, the effect of being liable is significant. You can be fined up to $500 per day per violation for a civil penalty, and then there are criminal penalties of up to $10,000 per violation and up to 2 years in prison. Basically it's a felony to not comply with the Corporate Transparency Act.
So then, Chris, question following up on Jonathan's example with his LLC, where there are 5 owners each with 20% and there are no officers. And Jonathan, you didn't mention, but perhaps it is a member managed LLC. So there are no managers and it's just 5 friends who co-own this cabin together. So in that case, if they don't file, who's the human being that would have to wear orange if they don't comply?
And Jonathan, do you look good in orange? I wasn't sure.
Well, you know, they say orange is the new black, and that's me.
All 5 have to report because you're all 5 members and it's a member-controlled LLC. But the simplistic example of a cabin, that shows how broad this is. Clients that have a simple LLC set up to own a vacation home, so that it could be transferred to a trust, they have to report. Everyone in the trust is going to have to report. Trust protectors on down. Let's keep moving, folks, because we want to get to the heart of this and get through the intro.
Let me ask another question. If you create an LLC, say for a client, because you're hoping to get a discount in valuation, I mean, you're not really operating a business. You have passive assets in there and not doing any real business with anyone. I mean, is that a company that has to report?
Absolutely, unequivocally.
Yeah, and Chris, how many of these companies, LLCs, limited partnerships, small corporations, whether they're S corps or C corps, how many are there in the United States?
FinCEN expects that there's somewhere in the order of 32 million of these reporting companies out there, and they also expect that number to grow by about 2 million entities per year.
Well, let me just get this. So we have 32 million, and I looked up, and FinCEN has a total of 300 employees. Now, I assume that's top-level people and also secretaries and maybe janitors and everything else. That, I think, comes out to a little over 100,000 reporting companies for each employee of FinCEN. That should be easy for FinCEN to handle, right?
Sure. I mean, why not? Really, what I think the problem here is that FinCEN has been tasked with enforcing a new type of regulation that falls really outside of whatever it's historically done before. FinCEN is largely in the business of pursuing money launderers, and a lot of how they do that is by regulating financial institutions. And so they've got sophisticated actors with dedicated compliance departments who are able to sort of meet these difficult compliance demands. They haven't been dealing with mom and pop people at the retail level who really have no infrastructure, no background for doing this. It's going to be a crisis. I think it's going to result in discriminatory enforcement. And I think it may well, in some circumstances, be used as an Al Capone type law to pursue people that FinCEN knows are bad actors, but it can't get any way else.
Right, but the worry for all of our clients is I would think almost every client is going to get swept up into this, and nobody should want to risk the advisor, the client, the company reporting people, the beneficial owners. Nobody should want to risk the kind of penalties that Chris laid out, even though there's no ill motive, ill intent, or inappropriate activity. Doesn't matter.
I'd like to add one more question for Chris, because I think other people may have this question. Chris, what about a single member LLC that is disregarded for income tax purposes? Does that matter? Does that mean we don't have to file?
No, the income tax treatment of an entity does not matter at all for Corporate Transparency Act reporting. And FinCEN has indicated that single member entities, disregarded LLCs and the like, will likely have to obtain their own separate tax ID number in order to comply with the law. They don't want to accept social security numbers for beneficial owners on the company's behalf.
And that's an interesting point, because a lot of the disregarded entities and disregarded trusts have used social security numbers, and that seems to have to change as a result of FinCEN. You're going to have to get a tax ID number, and that may be something you want to discuss with your accountant as to, gee, now that I have a separate tax ID number and it's not under my social, do I have to file a return for the trust or LLC or all the above that I had not filed in the past?
Okay, so I guess we've got.
Chris, tell us about the filing deadlines, please.
Well, the filing deadlines are not particularly generous. For all companies that exist in 2023 and before, they're going to have 1 full year to comply. So until January 1, 2025, if you have an entity that exists in 2023, you've got a full year to file. You need to file initial reports during that window. If you form an entity during 2024, there's 90 days to file initial reports. And then any entity formed on or after January 1, 2025 gets a mere 30 days to report. After filing an initial report, entities get 30 days to file any updates when their beneficial ownership information changes. That's things like the identity of your beneficial owners, a new manager, a new trustee, a new trust protector, anything like a change in address for a beneficial owner. That's going to need to be reported as well. And at most, there is a 90-day grace period for correcting incorrect reports at the absolute most.
And Chris, let me ask a question. What does that information about a beneficial owner consist of?
So a beneficial owner needs to report their full legal name. They need to report their date of birth. They need to report their personal address, their physical address. A PO box is not good enough. And then they will also need to provide a number from a valid identifying document. So an unexpired driver's license or unexpired passport, along with a copy of that document that contains that number.
That is going to be a major issue for many people. First of all, this is going to infuriate clients. They're going to take it out. My guess is on their attorney, as if we had anything to do with this, but why not blame the lawyer? And I think there's going to be a huge issue for older clients that may not drive and may no longer have a valid passport. This stuff can't be left to the end of 2024 to file by 1/1/25. If you have an older client that has no ID, you're going to have to get ID for them. They're going to have to get ID for them. So this is going to be a process. Think about what the trust protector of a trust that was named and never informed, never signed a counterpart to the trust, and now you call them up after not having talked to them in 10 years and say, hey, Jane, I need your driver's license, home address, and tax ID number. Hello. This is going to be a real mess. Chris,
and date of birth.
Yeah. By the way, today's my birthday. Let's go on.
Oh.
Congratulations. 43, huh, Marty?
Yeah, right. I
29.
dream on.
Happy 29th birthday, Marty.
Just send booze. It doesn't matter. All right, Chris. What are we going to do as practitioners to adapt to this?
Oh, I wish I had a very good roadmap for how we could do this, but this is the best we've got so far. So, I think we've got a couple of important steps we can do. I think first and foremost, warn your clients. Let them know that they have to comply, so they can't come back to you, 2 years from now, and FinCEN gets around to punishing them and say, you never told me about this. It'll be nice to point to multiple letters where you can say, well, I told you here and here and here and here, and I asked you to call me if you wanted help, and you didn't. I think we also are going to need to do things like modifying.
Hang on, let me comment on that. I know a number of accounting firms that are actually going out and sending marketing emails to promote the CTA work that they think they will do. And we'll maybe get to that. I know other accounting firms that as a policy decision said, we will not file any CTA filings. I received for the first time yesterday an email from a wealth management firm saying, here's what the CTA is, call your attorneys and accountants, meaning they're not doing it. I think a terrible mistake that some firms are making is, hey, we've decided not to do it. We don't have to get involved. That ain't going to happen. Think about what Chris said. Clients may assume you are handling this. If you're their accountant doing the regular tax returns, clients may think this is another reporting requirement. Of course you're handling it. You need to not only educate clients about the law, which I think is a service every advisor in every profession, wealth advisor, accountant, attorney, etc., should be doing, but I also think it's important, and Chris is going to come to this, to communicate what role your firm will or will not play. And it's not just in an engagement letter. The concern is the clients from 20 years ago. What do they think? You don't want to get embroiled in that. This is really important to think about. Chris?
Well,
Yeah,
Marty, let me add a couple of points here. You probably had clients that you no longer have for whom you created, say, a limited liability company, or you drafted a limited partnership, or you formed a corporation for them. They may no longer be your clients, and also you may not have records of it. Some clients decide, this is so simple, I'm going to form it myself. And yet, I think you have to give, kind of a shotgun approach to virtually everyone you represent, and everyone that you might otherwise communicate with, so the world knows. I mean, obviously, those of you who are listening to this appreciate there has been very, very little publicity given on this. I called a reporter friend at the New York Times the other day saying, this is really important. And there's been virtually nothing in the New York Times or any massive newspaper which has warned people about this. And he said, I'm sorry, I'm too busy. I'm on a bunch of other projects. So there are a lot of people who are not going to know. And the question is, what happens? And Chris, what happens, like that little LLC we have up in Alaska, one of the members is very, very difficult to deal with. And even though I think I'll probably be the one who takes on the responsibility for reporting, when I ask him for this information, he is likely to ignore me. And you can imagine if there's been bad blood between a couple of members or something, and one asks the other to do something, it's just going to go right in the trash. What do we do? Do we call FinCEN and say, hey, look, I'm trying to get this information, but I can't. What's the mechanism to get that information if it's not voluntarily sent to me?
Yeah, the mechanism, and I think you and Marty have written somewhat on this, is really hard to identify. It doesn't appear that there's any private right of action under the Corporate Transparency Act. You don't have the ability to compel someone who doesn't want to cooperate with you to cooperate. That's going to fall back on any organizing documents that you have, any authority you might create for yourself to expel a member. You might, modify your ownership interests so that only one person will be deemed to be a beneficial owner by, say, a handful of people transfer their interests to you. You could boot out the person who's not cooperative. But there's really not much teeth in the law for making sure that you, as the person who's responsible for reporting, get the information you need to report. FinCEN could obviously go after the person who's causing the false or fraudulent report to be filed, right? You're not there refusing to provide required information, but that doesn't let you off the hook as a person responsible for the company either.
Can I
I think that
Can I comment on, we don't know what the reports look like yet, but Jonathan, in your situation, it may be that when you go to file the report, if there's a way to explain for that one particular member, you have made XYZ efforts to get this information and they refuse to provide it, that at least hopefully will cover you as the one who's doing the reporting and make it clear that you have done everything in your power, but you have a uncooperative member.
Well, that's right, Abby. I mean, the thing that worries me is that there is no teeth whatsoever for enforcement. Remember, it is the reporting company which has the burden. There is no burden on a beneficial owner to do anything. And in fact, in the webinar that FinCEN put on recently, that question was basically asked, and really FinCEN ducked answering the question, saying, well, there are certain things that could be done to maybe get somebody to respond, but who's going to take that person to court? I mean, I've got a little tiny company. I don't want to hire a lawyer and spend thousands, if not tens of thousands of dollars to try to get that information. And I seriously question whether FinCEN will, because as Marty pointed out, there are going to be not thousands, but tens of thousands of people who simply won't know or won't be capable of turning in the information which the reporting company needs. I just think that this is something that really is almost a bottomless pit on trying to get compliance in thousands and thousands of cases.
Let me, millions is my guess, but let me make a couple of comments. I think what you need to do, if you are the person that is somehow responsible for filing on behalf of a reporting company, or you're an advisor advising that person, I think you want to document what you have done to try to get the information. And that would certainly include at minimum saving emails. But hey, let's get realistic for a second. Many of these people that you have to contact, such as a trust protector or an investment trustee or advisor named in a trust 15 years ago, you may not have an email for them. A lot of these entities were formed long before email addresses existed, before email was so common. You may have to send a letter to the last known address. If I were the reporting person responsible for a company, I would send emails if I have an email address. If I don't have an email address, I'd send a letter. I'd even recommend to clients, send a certified letter so you can prove that you were in good faith trying to get the information. And if the letter gets returned to you, send a letter to a new address. But realistically, a lot of these things are so old that forwarding mail may no longer be an option or a possibility for people that moved 5 years ago, 10 years ago. There may be no easy way to track these people down. And one final comment, I'm not sure, and if any of you want to elaborate, please feel free to. I'm not 100% sure that FinCEN's penalty structure may not somehow be applied to the beneficial owners who don't cooperate. It's really, the language is just not artful. It's hard to tell. I don't know if any of you have any thoughts on that.
Well, Marty, I've looked and I just do not see that there's any penalty on a beneficial owner, except maybe if the beneficial owner intentionally gives false information to the reporting company and that in turn is passed over. But if I'm just, I happen to be in a position where either I'm a deemed owner or I'm deemed to have substantial control, and Marty, as you point out, with people like trust protectors, because they give an example that you are you have substantial control if you, for example, can remove the senior officers of the board of directors. Well, suppose I'm a trust protector and I can remove the trustees or remove someone else. Or how about if someone has a presently exercisable special power of appointment where they can affect the disposition of the property, but they're not an owner and they don't have substantial control over the company. And, you'll get into questions like that. And I felt that FinCEN did not do a very good job of explaining what would happen, except they said, well, we could bring or they didn't say they could, they just said, perhaps an enforcement proceeding could be begun. And by the way, Chris, who pays for all this? I've got a recalcitrant member. How do I get the money to force them to do it? Is FinCEN going to send me a check to reimburse me for the legal fees?
Wait. Jonathan, you raised a fascinating issue about somebody holding a limited power of appointment, and you jumped to another topic without giving an answer. What would you recommend that somebody do that holds a special power of appointment who could appoint all the trust assets during lifetime?
Well, first of all, Marty, let me say.
Don't duck the question.
I'm not going to duck the question, but first, I think it's only if it's presently exercisable.
Yes, I agree with that.
Then you get a question, well, what if the trustee, through a decanting, could make it presently exercisable? The bottom line is that I think that when in doubt, file to avoid the penalty and avoid the hassle. You can imagine if FinCEN comes in and says, Chris, you didn't report and you should have. And Chris might say, I have a perfectly strong argument why I didn't do it. Well, you can go to court and fight with FinCEN and hope you won't go to jail, hope you won't face a $500 per day fine. But that is going to be tremendously costly. So This goes back to what Howard Zuritsky says: when in doubt, file. When in doubt, give the information. And I think that should be
go ahead.
done. Abby?
Well, I wanted to comment on the presently exercisable power of appointment. Chris, correct me if I'm wrong, but I believe that the guidance or the regulation with respect to trusts is that anybody who has the authority to dispose of or distribute the interest in the entity. So if I have a presently exercisable power of appointment over a trust that owns an LLC interest, I have the power to dispose. I think I have to be listed as a beneficial owner because of that power.
Sure, I'd agree.
Well, that's right. And then you get into questions about, okay, you're going to do it. Do you use your own tax identification number? Or because you're a fiduciary, do you say, I'm going to put in the trust's number? There will be lots of cases where a trustee has control over an entity, and the trust has a tax ID number for the trust. And do we put that number in? Do we put my personal number in? I mean, these are pretty important questions, and we simply don't have answers.
And so actually, Jonathan, if I may clarify there, so the trust is not going to be a reporting company. It will be the trustees are going to be beneficial owners. So the trust won't have to file a tax ID number, but you as the trustee or you as the trust protector would have to give your own personal information.
Right, but if I hold this power in a fiduciary capacity, and I don't want, to give out my social security number because I'm doing this as a trustee of this trust, and the trust has the tax ID number, why can't I use the trust number?
Well, they want Jonathan, they want to get to the humans behind all the entities. And so it's the human who has to provide the information. But that, for your example, because there are many trustees who will not want to provide their personal information to the other people in the entity or whatnot, that is why there can be a FinCEN identifier where, Chris, why don't you explain the FinCEN identifier?
A FinCEN identifier is very simple. Beneficial owners can give all the information they'd otherwise need a reporting company to file. They can give that information directly to FinCEN, and then FinCEN will issue them a FinCEN identification number that can be given to a reporting company in lieu of all that other identifying info. So if I don't want my people I'm in business with or people that I'm serving as a trust protector for to know where I live, I can just give them that PIN number, and then it's actually beneficial for them because it would appear that they are off the hook for any failure that I might make in the future to update my information with FinCEN. It shifts the responsibility for that updating to go from the company over to me. Question whether I might want that, but certainly most reporting companies will want to have that be the case because they don't want to be in the business of monitoring when everyone moves.
And Chris, how do I get that FinCEN number? I assume I can just go online and get it right now.
In keeping with FinCEN's long tradition of not making anything available in advance, there's no process you can use today to do that. But they promised us that it will be ready on January 1 and that you'll be able to go on their website and fill out a form where you give them all your information.
Well, it's kind of funny that they have all this stuff on January 1. The government isn't open on January 1. Nobody is open on January 1. So to think that it's going to be there is crazy. It's either going to be on December 31 or it's going to be after January 1. It's not going to be on January 1. And yet,
can you imagine this website not crashing when 50 million people try to get on and get their ID numbers?
Well, Marty, that's interesting. Chris told us there are 32 million companies plus an additional 2 million each year. There have to be what? 50, 75, 100 million, 150 million beneficial.
More.
I mean, I don't know how they're going to cope with it.
So let's get back to what we can do now, since we know we can't get our FinCEN identifiers now. Chris, why don't you get back, please, to the slide where we're talking about what to do with our engagement agreements?
Sure, happy to. I think modifying engagement agreements to make absolutely certain that clients, at least going forward, understand that you are not going to be on your own initiative filing beneficial ownership information reports on a client's behalf is absolutely critical. Spelling out how that relationship is going to work is important for every firm to have a handle on, and also to be able to point to for every client. If you can say, We agreed that we'd file the initial report if you gave us all of the information before it was due or by date certain, or you told us you were going to do it on your own. Having engagements that reflect that is going to be very important. And also modifying engagements that provide for things like ongoing general counsel style services for entities. Those may also need to be clarified to confirm things like that you're not capable of monitoring beneficial ownership on an ongoing basis, and they need to tell you if they need help filing.
One of the things that I've built into our engagement letter, and it's been in for many months already, because I just want everybody signing it as we get new clients. We are not accepting any CTA engagement unless there's a separate express CTA engagement letter. And I want to do that for exactly the reason Chris said, that I don't want a general engagement letter to somehow infer that we've assumed this responsibility. If we are going to do it, I want it very clear we have affirmatively decided to do it, and unless there's a separate engagement letter, we're not doing it. Because I really can see exactly what Chris was predicting, where clients, but you're my general counsel, why didn't you do it?
Well, Marty, what are you going to do when you can't have all of your clients sign that kind of engagement letter if they've already signed it? I mean, you may have had an engagement letter 2 years, 5 years, 10 years, 20 years ago with a client. And now you're going to go back and say, well, okay, you need to sign this acknowledging that we're not responsible to file for you under the CTA unless you separately engage us. I mean, one thing is, I think that's a really cold letter for a client to receive from its counsel.
I don't mind the coldness. I want it to be very clear who's doing what. And based on your comment just now, I'm finishing up my fourth quarter newsletter that will go out to all clients and to everyone in my contact list via email, as well as all clients in physical mail. And I'm going to add to that a statement, a disclaimer in bright, bold red, that I'm not assuming responsibility for CTA filings unless there's a separate engagement. That is probably the best I can do to communicate with everybody. But I think people need to think about this, because I think the point you raised, Jonathan, is spot on. Hey, you set up this LLC for me. Why didn't you take care of it? Well, you haven't been here in 20 years.
Or the accountant who does the tax return, because I think this will be viewed, all of it's under the Department of the Treasury, as the Internal Revenue Service also is. And I think that most people will feel, heck, you're doing my tax return, you should be filing this as well. In fact, I think one of the mistakes that was made is they probably should have put this in the hands of the Internal Revenue Service, which is used to dealing with forms and getting forms out and providing for extension. But there are no provisions for extensions here other than if you form a new entity in 2025, you've got to let FinCEN know within 30 days.
Chris, I guess you can go forward.
Sure. So, I think, that's, and these are all really good points. And I think that I like the idea of sort of, when we notify clients, and we've been doing this for months now, of telling them these new responsibilities are coming. We're assuming that you're doing this yourself unless you call us to tell us otherwise. Because at that point, and we tell clients we anticipate there'll be costs associated with it. And that's at least a way that we've identified for helping shift that responsibility to clients, and sort of putting the onus on them to pick up the phone and call us and enter a new engagement that's going to allow us to do CTA filings for them. We've also looked at things like updating our intake procedures, and I think that's another important thing for law firms who create entities and trusts to start doing, to make sure that you are getting the necessary beneficial ownership information before you create anything that could cause a new reporting obligation to exist. So that's, if I'm obtaining from clients their FinCEN identifiers and their legal names, that's easy enough for me. But this is something that's going to happen too. Will this happen, before an initial consultation occurs? I don't really see how it could. We don't know enough about what clients' needs are when they first pick up the phone and call us or first meet with us. But certainly after an initial meeting, collecting the names of everyone who will be an LLC manager or be in business with them in terms of owning an ownership interest, we'll need to get that information. And I think this raises sort of a question about when can firms agree to take on these filing responsibilities. I think you can take on the responsibility, or it's easier to choose to take on the responsibility if you control when the clock starts running. If you can't control when the clock starts running, it feels like a gamble every time. I can't say there's a road I won't walk down here necessarily, but that is certainly an area that I would be reluctant to take on an engagement.
Let me tell one thing about this. I mentioned that remote property we have in northern Alaska. My brother and my best friend all my life and I own a cabin together on the Kenai Peninsula in Alaska. And we decided, again, for purposes of really limiting liability, because we're not there all the time, to actually have it in an LLC. So we tried to form it, and I couldn't remember, so I asked Chris to look it up. And Chris, do you recall what you found out about that property or that entity?
Well, so I was able to look up, the entity based on, your name on Alaska's website. Not every state will have the same ability, but it's fairly easy in some states to identify who owns and who controls a property. But that information may very well be stale. That information in Alaska, at least, is supposed to be updated every 2 years, and it often will not be. And it won't reflect things like people who are, say, if there's an entity that owns an ownership interest in a sub-entity, we might not be able to find that. I believe there are 4 states right now that do not collect that information or do not make it public in any way. And so that would be an additional layer of difficulty and complexity.
But Chris, you found out that entity we had formed was not just inactive, but it had been basically dismissed because we hadn't paid our annual fees. Now, does that mean that entity is not a reporting company?
Well, I think this is going to vary from state to state. Under Alaska law, it's essentially impossible to reinstate a company that has been administratively or involuntarily dissolved for more than 2 years. Based on that, the company, I think, is dead. It's gone. It has ownership interests that will need to be distributed out to people. And so that creates a really thorny problem. Are we going to assume that this dissolved entity still exists for the purposes of transferring assets out? That feels like a gap in the controls that the CTA is trying to impose. On the other hand, it's no longer really an entity.
Chris, the way I read, wait, Jonathan, one sec. The way I read the CTA is I would want to look at the inactive status and see if it's inactive. It's definitely not inactive because it owns the cabin that Jonathan and his friends use. So I don't think it qualifies for inactive. I may be wrong, and maybe any of you have a thought, because I think what Jonathan's raising is a real significant issue for old entities that may have been had their charters revoked for failing to file annual reports in any state. I think it definitely depends on the status of what the state law says. But the way I read CTA, unless I've missed it, it focuses on was a filing made with the state in order to create the entity. I didn't see anything saying that the entity was dissolved by state state statute for failing to file. So it was formed. It doesn't meet the requirement for inactive. Is there an exception that applies in Jonathan's case?
And I hadn't considered it from your angle, Marty, but I'm not so sure that this is a question of the inactive entity. I think that will apply definitely in cases where for whatever reason a state has failed to dissolve an entity or does not dissolve entities as a matter of course within a period of time. This entity simply just does not exist as of the effective date of the law.
Does the law provide for that? I'm not sure it does. It only says you had to file to create the entity. It doesn't say anything about a valid entity still existing, does it?
Well, in that case, am I going to have to go back in time to find all entities that were wound up before 2024 and then file reports for them?
If it was wound up and has no assets, it's inactive.
Right. I think we have to look at that inactive status, inactive entity exception. And for all of our listeners, if you're not following, please do go back to the prior materials that Marty mentioned at the outset, because there is an exception for an entity that is inactive. But the rule, there are a number of rules, one of which it doesn't do any business, another of which it has no assets, and it doesn't receive more than $1,000 in receipts, I think, within a year. Don't quote me, go look at the rule. But in any event, I think Marty and Chris, with respect to what you're saying, if I created, Abigail LLC back in 2002 and dissolved it in 2004, and it has no assets and it doesn't do anything and there are no receipts, then regardless of whether or not the rule says that I don't have to file because it was dissolved, it would qualify under the inactive exception, so I don't need to worry about it. But for Jonathan's situation, where it does have an asset, my opinion only is that you do still have to file because it has an asset. And if you're able to escape reporting by simply allowing your state to involuntarily dissolve the entity from a structural perspective, I think then that situation would be ripe for abuse. I don't think they will allow it. It may take a while to catch up with the rule, but my feeling is if the entity has been involuntarily dissolved by the state, depending on state law, but at least in Alaska, where I'm licensed, I certainly would file for that entity if it owned real estate.
Now,
Can I?
suppose, Abby, this entity is owned by someone or multiple people who are beneficial owners, and they're married, and the property is community property under their home state. And in fact, the cabin we have in Alaska, two of the people who are 20% owners, only 20%, but again, because we are member managed, maybe everybody has a responsibility. What about their spouses? And in fact, when I formed this entity, I actually not only had them, but I had their spouses sign as well. So I think, where you have something like a jointly held piece of property or community property, you've really got to think about, who do I have to report for? Maybe just not the wife, maybe not just the husband, but for everybody. And as Chris was stating before, there are exceptions, for example, for minors. And if you have a minor succeed to the ownership of property, say through a decedent's estate, at what point do you have to report for that minor? And what if the minor has a guardian? What if someone becomes incompetent and there's a guardian appointed for them? And
Jonathan, let me address the community property point you raised, and please correct me if you or Abby or Chris think I'm wrong. If the community owned a 50% interest and that's deemed half each, they have to file as beneficial owners because each spouse has arguably a 25% interest. In your case, where each couple may have a 20% interest, if in your case the husband signed as the member, even though the wife may have an interest, she's not a beneficial owner by owning equity. The husband would be a member and therefore a control person, so maybe only the husband files, not the wife.
Well, this gets back to the fact, Marty, that my advice is, when in doubt, file.
I think there's another piece of advice that maybe one or all of you want to comment on. What really concerns me about the discussion we had a few minutes ago, where Abby and you were talking about limited powers of appointment being exercisable during lifetime, and perhaps triggering a control position because you can dispose of the assets. The nuance of whether or not an entity that's been dissolved under state law has to file or not have to file. These are really nuanced, fine legal points. Will an accounting firm or a wealth management firm or a service company that you're paying a couple $100 to, will they have the wherewithal to really make these types of distinctions and do this type of analysis? Doesn't this kind of suggest that for anything but a plain vanilla situation, you have to have counsel involved? Thoughts, anyone?
And who pays for that, Marty? I mean, all of a sudden, you wind up, having a complicated situation, maybe where people have died, maybe their estates have gone through kind of a probate proceeding, but it's still pending. Maybe there's a will contest. You don't know who is going to be the inheritor. You remember there are rules in the tax law which say that an entity like an estate or a trust at a certain point is disregarded for income tax purposes, but maybe not for purposes of the CTA. We simply don't know.
What do you think about non-lawyers getting involved in these types of distinctions? Anybody?
I think they are at risk for giving uninformed advice.
It's dangerous.
Yeah.
See, one of the things that I think is going to happen is, my guess is a substantial majority of CTA filings are going to be obvious and simple. Me and Jonathan and Abby and Chris, we each own an LLC. We each own 25%. It's member managed. The four of us have to file. You know, that's simple.
No,
But
no, we don't have to file, Marty.
the company does.
The company has
Correct.
to file.
We have to give it we have to give it the information. But once you get beyond the plain vanilla,
Marty, when you say we have to give the information, where's the law that says we have to give that information?
I agree with you. I'm just trying to make another point. I think a lot of these things are going to be very, very simple. But once you take one step beyond simple, I think this stuff is going to entail incredibly complex, nuanced legal decisions. And it's not only a decision when in doubt, file. You got to identify all the people in a trust or an entity that may even have to file. That in itself is complicated. Chris, maybe you want to comment. Does somebody with a loan that has an equity kicker, do they have to file? Does a tenant with a percentage rent potentially have to file? I mean, how far does this all go?
You know, certainly we've got some clarity regarding, you know, people who hold, you know, creditors who can convert their debt instruments into equity can be deemed to be beneficial owners. You know, for tenants that pay percentage rent, that's not really been addressed. I don't think so. But, you know, I think we're still waiting on so much information back from FinCEN that it's really hard to you know, answer these close cases. I know FinCEN held a webinar yesterday where they said they recognized that trusts were a complicated area. They wanted to do it. You know, and this is less than 20 days before the law becomes effective. I mean, if they're not giving us advice now, if they're telling us they're punting on that advice, how could we possibly comply?
I think we all have to do two things. I think when it's anything but plain vanilla, you have to get an attorney involved. And it may not be one attorney, right? I do only estate work. I don't hold myself out as primarily corporate counsel. So you may need corporate and T&E work. And even if you're in a big firm, you're going to need a T&E partner and a corporate partner, or maybe a commercial lending partner to figure this all out. And secondly, I'm going to repeat what Jonathan said is going to become the mantra: when in doubt, file. But then, oh my, you have all this practicality. How are you going to get the information?
So let's on that note, since you're talking about firms and how firms are going to handle it, back to what Chris was talking about on our important next step items. Chris, can you talk about firms deciding whether or not they are going to handle CTA reporting? Because I think that is something that it would be helpful for a firm to make that decision before the requirement begins.
You know, I think that's a really good point, Abby. You know, there are going to be, you know, some small firms that do not have the capacity to take on additional reporting requirement type of related work. Frankly, they've got better and more interesting things to do with their time. And they don't have staff who can do this work. They don't wish to do it themselves. They may just need to sort of, as a blanket rule, pass on beneficial ownership report filings and make it someone else's problem. So that's kind of the first question. Do you have the capacity to take on the work that's associated?
So let me talk about that for a minute, Chris, because I am a solo practitioner. I have one full-time assistant and a very part-time paralegal. I do not have the capacity to take on CTA reporting. And I've made that clear in my alert that I sent out to my clients, and I've followed up with them and talked to them about it. So what does that mean? Because my first reaction was, well, great, I can just refer that work out. But the truth is, are there lawyers who want to take on just that piece? And I don't know that there will be firms, at least in Alaska, that are willing to take on engagements only for the purpose of CTA reporting. So there may not be anyone to whom I can refer the work. So I've been trying to come up with, okay, how do I help clients do it themselves? And I don't really know the answer yet because, of course, we haven't seen the form and things like that. What I imagine I will be doing is another follow-up alert once the reporting requirement begins and once we have a website with a link to file the report. I am imagining that I will send out a follow-up alert that says, hey, to do this yourself, go to this website. Because in my initial alert to my clients, I did put the FinCEN website on my alert for more information. And I have had clients contacting me telling me that they have gone to that website. So the clients, if they're being proactive, I think if you provide them with some basic information, hopefully they can at least get there and you're helping them do it themselves. But I don't have the right answer, but I think this is something that I've at least thought about, and other firms and other solo practitioners should probably spend some thought.
Abby, when you sent your clients to the FinCEN website, what did they find? Did they find
Nothing.
the form? Did they find the instructions? No, they found absolutely nothing.
Nothing. But one of them told me, and I just got a letter from her yesterday, that she will keep checking it. And you know, I think a lot of this is about educating your clients, making it clear. I have made it very clear I don't have the capacity to do it, but that doesn't mean I cannot provide them with some guidance on how to do it themselves, which is what I intend to do.
One of the things that worries me, building on what Abby just said in the last bullet on slide 12 about economics, if a client comes back to me that had a trust that was set up 10 years ago, 20 years ago, and that trust owns a multiple of different entity interests, how do I know what's going on? How do I have any idea who the current trustee is, who the trust protectors are? How do I know that someone hasn't exercised a power of appointment? Might I need the person that holds that lifetime unrestricted limited power of appointment to sign a document confirming they've never exercised it? Otherwise, how do I know what's happened? These people haven't been back in 10 or 20 years. I don't know what's going on. And getting to economics, if I have to go through a trust that's 10 or 20 years old, I don't think I would be comfortable doing that if I could not also provide a memo to the client commenting on issues I see in the trust. Because if I go through the whole trust document to identify the people that may have to report for CTA or that you may want to get confirmation haven't done something that might change the trust, how can I not also advise the client of issues I see in the trust that a simple decanting may resolve? Otherwise, I've stuck my foot in the water, not my toe, I think my foot. And if there's an issue with this trust down the road, aren't they going to come back and say, you reviewed the whole trust? How could you not tell me that there were these issues? I don't know the drafting and engagement letter saying, and this goes to Abby's point of, will a firm take on a pure CTA filing? It scares me. How do you get involved with entities and trusts with all these complex issues? And if you see a problem with something, not address it, or at least put it in writing so that you've protected yourself. Chris, any thoughts?
I mean, realistically, this is just going to spiral out of control and not be something clients want to engage, a law firm to do. If I ask for, a $10,000 retainer to review a simple filing, I wonder if my clients are going to say, why not just go it alone on the insurance market and try to cover my interests in property that way and get rid of my LLCs? That's what I worry about.
Well, to think that we will be advising clients not to use corporations and LLCs or limited partnerships because of the potential exposure that direct ownership can do, not just losing that property, but becoming liable for your entire wealth. I just think we have to do it, and I think that will continue. I mean, FinCEN thinks there'll be an additional 2 million entities, per year that are added to the 32 million they say that are already there that will have to report as reporting companies.
Jonathan, apropos to Chris's comment, somebody emailed me that they think what they'll do is tell people to dissolve their LLCs that own real estate and business interests and have them owned in a trust because somehow they think that the trust structure will insulate the trustees and others from liability. How would you comment on that?
Well, Marty, in most states, a trustee is liable for things that come against the trust. So don't think that, well, I'll just put it in a trust because the trustee will be liable. And even you say, well, I think I can beat that somehow by having the trust in some jurisdiction where trustees are not liable. But I am personally unaware of any state which says that a trustee is not liable for a liability arising from that piece of property. Or if you own a business, for example, and you put it in a trust, the trustees are almost definitely going to be liable if a claim is made. I certainly wouldn't act as a trustee of that trust. Chris, would you?
I wouldn't.
I wouldn't. I don't think, I'll answer for Abby. No.
Oh, no, I didn't think I needed to answer for that one, but no. And I've had this conversation now with about 3 or 4 clients in the last several months about their LLCs. And, because the obvious question is, well, do I still need it? And so almost all of my clients, the answer was yes. I have one client where the LLC didn't hold any real estate. It was not serving any purpose anymore. It was just holding some investments. If there were no discounts that were going to be helpful or any of those things. For that one particular case, they thought, okay, they just want to dissolve the LLC. But for everybody else, especially those with real property and for ongoing businesses, no, it was sound planning, and it still is sound planning. And this is yes, one more cost of good planning. But as we all tell our clients, you don't get protection and good planning for free. There's stuff, and this is now one more piece of that.
I fear this is going to be a big piece of stuff.
At least for the first period of time until we start seeing the forms roll out and the compliance roll out and people start sharing their experiences. Yes, I agree. So.
I think the initial filing for complex situations is going to be a massive undertaking. And my fear is that if I take this on, just like Chris said, if you ask for a 10 grand retainer, the client's going to think you're crazy. But you know what? If it's a simple thing, clients should do it on their own, just like you said, Abby, because you don't need a lawyer if you got 3 people that own an LLC and the 3 of you have to file. But when you get beyond that to the complex commercial or estate planning trust implications, I think these are major undertakings.
I agree.
I think we have just a few minutes left. Chris, why don't you finish any thoughts that you want for 5 minutes, and then everybody can make some concluding comments. And one point I will make is this webinar demonstrates how unbelievably complex this is and how each piece of new advice that we get from FinCEN just makes it seemingly even more complex and still leaves open a myriad of issues. So I'm going to ask Chris and Abby and Jonathan to agree to do yet another follow-up and maybe a whole series of follow-up webinars as the stuff unfolds, because there's a lot to unpack here, as the saying goes. Chris, how about some last thoughts, comments, points that you think we should make that we didn't get to?
I think it's going to be important for us as attorneys to sort of identify where in our processes we can at least make this easier for ourselves and our clients going forward. So simply going through existing form documents and looking for anything that can affect how beneficial ownership can come into existence or how it can end, or any rights to dispose of property, identifying those and including in things like trust documents, language that will help us identify when we're drafting documents in the first instance, what provisions of this trust document might cause someone to become a beneficial owner, so that I can give my client a separate letter or an addendum that helps them comply going forward, so I don't need to be looking over their shoulder. And I think that's an important process for attorneys if they haven't started that to try to go through. I know we've covered a lot of those provisions in past webinars and in other materials as to what might cause someone to be a beneficial owner. This is, I think, just a basic process step that will avoid a lot of heartache and save a lot of time for us as drafting attorneys going forward.
Abby, final thoughts, comments?
Final thoughts are to spend the time now and think about your message to the client, get your message out, get the notification out, and be ready with a response for, okay, well, what do I do next? And everyone's message to their client's going to be different. If you and your firm want to take on the reporting requirements, then be ready for it. But think these things through, because clients are going to need us as their advisors to have a level head and at least be able to give them a place to go to deal with this.
Jonathan?
Well, I think what Abby and Chris said is just completely accurate. One of the things you've got to decide, is your firm going to take this on? And how upset are your clients going to be if you say you won't do it? But determining how you would charge, and again, this is a relatively simple form. So, you can say to your client, do it on your own. But if they make a mistake and FinCEN comes after them, and they come back and they say, well, you told me I could do this myself. Again, the attorney or the counselor is going to be in a very awkward position. But yet I can see, especially when you're dealing with trusts, which all estate planners deal with, and the trusts have different terms, and you not only have a trust protector, but you have a guardian of the trust protector, which can remove the trust protector. And what if you have a loan director who can force the trust to make loans to the grantor, which is something that's used to make the trust a grantor trust? All of a sudden, how do you handle these things, and whom do you report about? Remember, it is the company's responsibility to report about its beneficial owners. It is not the beneficial owners directly, which I think was a mistake in this legislation, to do it. Because I guarantee you will have some people who either are unaware of it or simply will ignore it, or you can't get a hold of them. And that could be problematic.
I think going forward, we are going to include in entity and trust documents a commitment by people given certain appointments or powers to obtain a FinCEN ID number and give it to the trust, the entity, etc. Because if that's not done, there's no way to enforce it. I think Jonathan has identified, and all of us have had some discussions about what you can do as a reporting entity to get a beneficial owner to give you the necessary information. That's a gap in this whole FinCEN CTA Corporate Transparency Act structure. And I think they have to address that, because even if prospectively we put provisions in where people are going to say, all right, I'm going to be a trust protector and I agree to give you a FinCEN ID number, what do we do about the myriad of trusts and entities and things that exist already? I think it's got to be addressed, because it's going to be a terrible problem. I think one of the big sort of issues is, for a lot, maybe the vast majority of entities, is going to be fairly simple, but for a huge number, this is going to be beyond incredibly complex. And I don't think clients are going to appreciate it. My fear is, and I think I said this on the last webinar or two that we've done, is that a client's going to see it's like a 4-line item. Like, why are you charging me, Chris, 10 grand as a retainer? There's only 4 items I need to put there. Well, but the complexity is figuring out who needs to put it and why, or documenting why they don't. That's where the difficulty is. It's not the form. The form is relatively simple, but it's getting there. So I think we all have to be very careful. And frankly, the more advisors and the more different professions that help educate clients, the better for all of us. So we should all send out newsletters and announcements and webinars to try to educate people. And I wish the media would pick up more on it, because as Jonathan said, there's not been a lot of coverage, and this is huge.
Well,
Any final thoughts?
Yeah, let me just say something, Marty. Even if you only have a problem with 1 in 1,000 reporting companies, and I think that's a very, very low guess, but assuming it's only 1 in 1,000, that means there are 32,000 reporting companies that you're going to have problems with. 32,000. And I just don't know how we're all going to be able to cope with that or advise people about it. And I certainly don't know how FinCEN is going to handle this. And, they might say, well, we're only going to do it to bad people. But they shouldn't have put this legislation as it exists in place if that's the thought, that we're going to selectively go after people. I think that's a bad way to have laws work, that we'll decide who we come after. And again, they want this information so they can try to figure out who are the, bad actors.
Chris, any last words? Why don't you wrap it up?
Well, I think we've really captured just how difficult it's going to be for attorneys and other advisors to sort of bring themselves into a world where the CTA shadows every action we undertake on behalf of clients who have LLCs. and communicating with people the costs associated with that, not only to their pocketbook, but also to their civil liberties and to the privacy that they hold very dearly, is going to remain a challenge well through for as long as the CTA in its current form is on the books. And I think that as people become more aware of the problems in the CTA, I think I hope there will be pressure on Congress to do something to shave off some of the sharp edges of this law so that good people doing their best to comply with it actually can.
Thank you everyone for joining us. As with all webinars, this is for educational purposes only. Don't make any legal decisions based on our comments, and especially with respect to the CTA. Thank you, Chris, Abby, Jonathan, and take care, everybody.
Thanks, Marty.
Thank you, Marty.